Hello dear students, today we will discuss pre-incorporation contracts. The main objectives of this lecture are to study the concept of pre-incorporation contracts, to study the significance of pre-incorporation contracts, to analyze the liability of the promoter for pre-incorporation contracts under the contract law, to analyze and examine the liability of promoters for pre-incorporation contracts under the Specific Relief Act 1963, to analyze various judicial decisions dealing with different aspects of pre-incorporation contracts. A company that has been legally incorporated and registered is referred to as company under the Companies Act 2013. In other words, a corporation is not legally recognized as a company in India unless it has been properly registered. Therefore, the association of persons is not regarded as a distinct legal entity until the company is formally incorporated. A corporation must enter into multiple contracts and incur several startup expenses before it can begin operations. Contracts entered into by promoters with third parties to obtain some property or right for and on behalf of a yet to be formed company are referred to as pre-incorporation contracts or preliminary contracts. All business dealings or promises of business dealings that are meant to be in the future company's best interest fall into this category. All business dealings or promises of business dealings that are meant to be in the future company's best interest fall into this category. In other words, it can be said that an agreement made by a person for a business that has not yet been incorporated is known as pre-incorporation contract. The contrast in terms of the beneficiary is the theoretical distinction between a pre-incorporation contract and an ordinary contract. Although the promoters and a third party are the parties to the contract, the intended beneficiary is the potential firm that has not yet been incorporated. The person who signs a pre-incorporation agreement is known as the promoter. Promoter is defined under Section 2, Clause 69 of the Companies Act 2013 as a person identified by the company in the annual return under Section 92 or who has been specifically mentioned in a prospectus as such. A person having direct or indirect control over the company's affairs, whether as a shareholder, director or otherwise, or a person whose directions the board of directors acts. It must be kept in mind that this section defines the promoter only after the company has been formed and not before. In the case of Taycross versus Grant, Cockburn Justice described a promoter as someone who takes the appropriate actions to form a firm for the purpose of launching a particular initiative. In Valley Bridge Calico Printing Company versus Green, Bowen Justice argued that the term promoter is not a phrase of pure law, but rather a term of business and denotes a range of business processes known to the commercial world through which a corporation is brought into existence. Now we will discuss promoters' liability. At the time of pre-incorporation or incorporation contracts, the promoter or promoters of a company have a fiduciary relationship with the company that they have promoted. This fiduciary relationship or trust and confidence relationship gives rise to specific duties on the part of the promoters in various instances. The Companies Act specifies the various obligations that might be imposed on the promoter in the event of a breach on the side of the promoter. The numerous liabilities that the promoters may face are: in the event that complete disclosure was not made at the time the contract was made, the corporation may either revoke the contract and recover the price of the contract they purchased, recover the profit even if rescission is not claimed or is impossible. In the event of a breach of fiduciary responsibility, the trust firm may seek damages. Now we will discuss liabilities under the Companies Act 2013 vis-a-vis promoters. Section 26 provides that the prospectus must include all incorporation related items and reports. If any of these conditions are not met, the promoter will be held accountable. Section 34 and 35 of the Companies Act of 2013 hold a promoter accountable for any untrue statement in a prospectus to a person who subscribes for shares or debentures in reliance on such prospectus. However, the promoter's culpability in such a case is restricted to the original allottee of shares and does not extend to future allotters. False statements can have the following consequences. The securities allocation can be set aside. It is possible to sue for compensation and damages. If necessary, the promoter may face criminal charges. Section 300 states that a promoter, like any other director or officer of the company, may be subject to investigation if the court orders it based on a liquidator's report claiming fraud in the promotion or establishment of the firm. A company may bring an action for fraud or breach of duty against a promoter under Section 340 if the promoter misapplied or kept any company property or is guilty of misfeasance or breach of trust in connection to the company. In Prabir Kumar Misra versus Ramani Ramaswamy, the Madras High Court decided that it's not required for a promoter to be a signatory to the memorandum or articles of association, a shareholder or a director of the firm to be liable. The promoter's civil obligation to the company and third parties remains in respect of his behavior and contracts entered into as the business's agent or trustee during the pre-incorporation stage. Now we will discuss significance of pre-incorporation contracts. Incorporation of a company provides many benefits to a person in a corporate structure, since it allows individual owners or shareholders to protect themselves from financial liabilities, because after incorporation, it is the company that enters into debt. As a result, prior to the incorporation of any company, we can consider pre-incorporation contracts to determine the roles, functions, and liabilities of any organization. Individuals may opt to draft pre-incorporation contracts in two instances. Internal arrangements. Before the incorporation of concerned firm, we can decide on the responsibilities, functions, and obligations of each incorporator, such as who will be directors, financial head, legal head, and so on, and what their liabilities will be. We can also draft the company's rules and regulations once it has been fully incorporated. This agreement also allows us to decide what perks will be provided to incorporated employees who will be part of the company, such as apartments, automobiles, and any other benefits that they would receive. Then we have business agreements. When we form a company, it is apparent that the company will interact on a regular basis with many other corporations and companies. As a result, a pre-incorporation contract will shield your firm's operations prior to incorporation, as this contract may indicate whether or not this company has limited liability prior to the release of incorporation information. This agreement further states that following incorporation, true ownership will be transferred from promoters to a firm. Pre-incorporation contracts are critical agreements. Any company, control, or operation for the prospective business must be incorporated during the pre-incorporation phase. Through writing a pre-agreement by negotiation on complicated subjects, an absolute incorporation contract helps us to avoid future problems. By preparing a pre-incorporation contract with promoters, you can ensure that everyone involved in the incorporation of this firm is clear on the idea, strategy and business, which help us to avoid future disagreements. Now, dear students, we will discuss legality of pre-incorporation contract. A pre-incorporation contract's legal standing is difficult to establish. According to the definition of the contract, at least two parties or persons must enter into an agreement with each other. As a result, the general idea is that no contract exists if one of the party to contract does not exist at the time the contract is entered into. As a result, the firm cannot enter into a contract before it comes into existence, and it comes into existence only after it is registered. It may be claimed that the promoters enter into the pre-incorporation contract on behalf of the company. But there is also a complexity here. While entering into the deal, the promoters function as the company's agents. But if the principal, that is the corporation, does not exist, how can it designate an agent to work on its behalf? As a result, even though they pretend to be acting on behalf of the prospective company, the promoters, not the firm, become personally accountable for all contracts entered into by them. However, under Section 230 of the Indian Contract Act, an agent cannot personally enforce contracts entered into on behalf of his principal, nor is he personally bound by them if he expressly states at the time of making the contract that he is only acting as an agent and is not personally liable under the contract. So, if this principle is applied, the contract becomes ineffective because neither party is obligated under the contract. Thus, there are two important issues so far as legality of pre-incorporation contract is concerned. These are: a company cannot be sued on pre-incorporation contract. In CIT versus City Mills Distributors, it was held that a contract requires two willing parties. However, the firm is a non-entity prior to incorporation. Prior to incorporation, a company has no legal status. For tax purposes, it cannot have any income prior to incorporation. Similarly, shares cannot be purchased in a company's name prior to its establishment. In Intlic Investment Private Limited versus Dynamatic Hydraulics Limited, it was held that a transfer form is likely to be rejected if the name of the proposed company is included in the transferee column. Hence, the legitimacy and enforceability of pre-incorporation contracts are continually called into question. Again, in English and Colonial Produce Company Re, on the directions of certain gentlemen, a solicitor prepared the appropriate documents and obtained registration of the company. He paid the registration fee and the registration related charges. However, the corporation was held not bound to pay for those services and fees. It was determined that the corporation could not be sued when the expenses were incurred. In AP Tourism Development Corporation versus Pampa Hotels Limited, an arbitration agreement was deemed to be non-existent when the corporation with whom it was made was incorporated later. Company cannot sue on pre-incorporation contract. It is not entitled to do so. In Natal Land and Colonization Company versus Pauline Colliery Syndicate, N Company reached an arrangement with 1C who represented a potential syndicate. The agreement stated that N Company would lease coal mining rights to the syndicate. The syndicate was then formed, struck a seam of coal and requested a lease from N Company, which was denied. The syndicate's action for particular performance of the agreement or in the alternative for damages was dismissed, since the syndicate did not exist at the time the contract was executed. In this case, it was decided that a business cannot obtain the benefit of a contract purportedly negotiated on its behalf prior to the company's formation through adoption or ratification. Now, dear students, we will discuss personal right and liability of contracting agent. In the case of contracts made on behalf of the proposed corporation, the question is whether they can be enforced by or against the agent who acted on behalf of the proposed corporation. The answer will be determined by how the contract is written. If the contract is made on behalf of a firm that does not yet exist, the agent may face personal culpability. For example, if a contract is made on behalf of a principal who is known to both parties to be non-existent, the contract is considered to have been created personally by the actual maker. Similarly, if a person professes to contract as an agent, he may nevertheless reveal himself as a principal and file an action in his own name. In Kellner versus Baxter, the plaintiff planned to sell wine to a newly formed company, but the contract required him to sell only to the proposed directors of the company. The proposed directors meant to buy the wine on behalf of the company, but because it did not exist when the transaction was made, they accepted delivery themselves. It was held that because they had negotiated on behalf of a person who did not exist, they must pay the money for the wine they had received. As against it, in Smallwood versus Black, a land vendor could not sue for specific performance the directors of a proposed company who contracted to buy something under the name of the company, which subsequently refused to adopt the purchase. The relationship between a business and its directors is not the conventional one of principal and agent. Thus, a contract purportedly formed by the company cannot be enforced by or against the agent through whom the company negotiated. When a company contracts, it is the company that contracts, and the signature of one or more of the directors only authenticates the contract. In Newborn versus Sensolid, the plaintiff was a promoter and prospective director of a limited company called Leopold Newborn London Limited, which had not yet been registered at the time of the action. The corporation signed a contract for the supply of goods to the defendants as Leopold Newborn London Limited, with the plaintiff's name Ellen put underneath. In an action for breach of contract brought by the plaintiff against the defendant, it was determined that the contract was made not with the plaintiff, whether as agent or as principal, but with a limited company that did not exist at the time of the making, and thus it was void, and the plaintiff could not adopt or sue on it as his contract. The judgment of the Bombay High Court in Ram Kumar Poddar versus Sholapur Supning and Vogue Company Limited had the same consequences. A condition in the memorandum of a proposed corporation stated that a specific firm would be designated as the company's managing agent. The company appointed them after incorporation, but the board later decided to fire them. In an effort to prevent the firm from breaching the contract, it was determined that such a language in the memorandum or articles does not create a contract between the company and an outsider. Even though it is an implied contract, it was a preliminary contract made by the promoters before the incorporation of the firm. Under the Act, it is not permissible to establish a business bound by a previously made contract. As a result, it appears that the courts want to shield the new company from the weight of promoters' pledges because those promises are infamously extravagant and would bind the corporation to a number of expensive, unfair, and unknowable responsibilities. With this protection comes some sacrifice, as the firm cannot bring a claim against a shareholder who has an agreement to purchase shares prior to incorporation. People who provided services prior to incorporation occasionally had to work for free. In this case, the courts will do all in their power to hold the promoter personally liable. For instance, in Toche versus Metropolitan Railway Warehousing Company, third parties provided services to a company prior to its formation as part of a contract with a promoter. Since the third party was unable to file a lawsuit, it was decided that the promoter would have to do so on their behalf as a constructive trustee. Now we'll discuss how can promoter shift his liability. First, we have Specific Relief Act. Although the promoter is personally liable for the pre-incorporation contract under common law, there are specific circumstances in which the promoter might shift his liability to the company. He can transfer his liability to the firm under the Specific Relief Act of 1963. This can be done under Section 15 and 19 of the Specific Relief Act of 1963. Section 15, Clause H specifies that if the pre-incorporation contracts are entered into by promoters for the purpose of the company and are subject to the requirements of the company's incorporation, the business may request specific performance from a third party. In Wali Pattabhirama Rao versus Ramanuja Ginning and Rice Factory, a person purchased a leasehold interest in a corporation in order to promote it. He held it for a partnership firm for a while before converting the firm into a company that adopted the lease. Under the lease, the lessor was held bound to the corporation. In Jai Narayan Parasrampuria versus Pushpa Devi Saraf, the Supreme Court ruled that while the corporation must accept the transaction, it is not required that the transaction be mentioned in the company's articles. The fact that the business was seeking a declaration of ownership of the property that the directors had purchased for it prior to incorporation was enough to indicate acceptance of the transaction. Similarly, relief can be obtained against parties under subsequent title under Section 19, Clause E of the Specific Relief Act, if the newly incorporated firm accepted the pre-incorporation contract and notified the opposing party of its acceptance. In Weavers Mills Limited versus Balkis Amal, the Madras High Court broadened the applicability of this approach. In this case, the promoters agreed to buy several properties for and on behalf of the company being marketed. When the firm was formed, it took possession of the land and began to build facilities on it. It was decided that even if the promoter did not deliver property to the business after its incorporation, the company's title to the property could not be set aside. If the contract is not approved by the company at its meeting, it is binding on the promoters, and both the promoters and the other party have the right to demand performance from the other party. As is correctly stated, ratifying contracts for the purpose of their enforcement by a firm is unavoidable. The proponents can accept the contracts by passing a resolution ratifying the contracts and all other actions taken or done by the promoters in order for the company to be incorporated. The second thing is novation of contract. It is the substitution of an existing contract with a new contract, either between the same parties or between different parties. In Scarf versus Jardine, novation was defined as being an existing contract. Some new contract is replaced for it, either between the same or other parties, with the consideration mutually being the discharge of the previous contract. Thus, the most significant part is the termination of the previous contract. The parties would be bound by the new contract upon completion of the novation. Novation differs from ratification in that a new contract is made on the same terms, but this time between the company and the third party, whereas ratification dates back to the time of the act ratified, so that if the company ratifying, which is no longer in existence, cannot have performed the act in question, its subsequent ratification of it is ineffective. In the event of novation of contract, the company may replace the promoter from the pre-incorporation contract. However, one could argue that such a contract should not be labeled a pre-incorporation contract, but rather a post-incorporation contract, because novation of contract results in a new contract. The English court, however, accepted novation of contract in Howard versus Patent Ivory Manufacturing. Another one is doctrine of equity. In India, the company can be held accountable under the doctrine of equity. In Weavers Mills Limited versus Balki Zamal, the company was deemed accountable because it benefited from a pre-incorporation contract. However, under English common law, the position is different. According to Chitti-on contract, the firm cannot be accountable for pre-incorporation contracts even in equity. Now, to conclude, dear students, we can say that pre-incorporation contracts are preliminary contracts formed before a company's incorporation. This essentially assists the organization in establishing future rules and regulations. It establishes the roles and obligations of all promoters towards shareholders who will be part of the firm in the future, which aids in dispute settlement in the event of ambiguity. It may appear that pre-incorporation contracts have no legal validity, but as demonstrated by the aforementioned case laws, they are valid and valuable, allowing company promoters to earn rights and properties prior to the incorporation of any company. The company may or may not enter into pre-incorporation contracts following its incorporation. It is entirely up to the company's promoters whether they wish to incorporate it or not. It can be included by novation or by simply embracing the express and implicit benefits of this contract. With this, we end today's lecture. Hope you enjoyed it.